The Supreme Court has officially agreed to hear what is shaping up to be the next major Second Amendment battle. And once again, the core issue revolves around concealed carry restrictions that certain states pushed through even after the Supreme Court made its position clear in the Bruen decision. That ruling was a 6-3 decision, and it told states in no uncertain terms that they could not impose may-issue permitting schemes or create arbitrary barriers that make it nearly impossible for law-abiding citizens to carry a firearm for self-defense. Despite that clear message, states like Hawaii, California, New York, New Jersey, and Maryland responded by passing new laws designed to achieve the same restrictive outcomes under a different label. Now the Supreme Court is stepping in again, and this time the Trump Department of Justice has filed a powerful brief in support of striking down these laws. Their involvement has added even more weight to this case, and gun owners across the country are watching closely. The case the Supreme Court has taken up is called Wolford versus Lopez, and oral arguments are scheduled for January. The Wolford challenge came out of Hawaii, a state well known for its extremely restrictive gun regulations. After Bruen, Hawaii passed a new set of rules, but instead of moving toward a shall-issue system that respected the rights of lawful citizens, the state created a new web of restrictions. One of the most controversial rules is what's known as the affirmative consent requirement. Under this rule, a concealed carry permit holder is only allowed to carry a firearm on private property if the owner gives explicit permission. That permission can either be verbal or through a posted sign saying that concealed carry is allowed. Without that specific permission, carry is automatically banned. This change had massive consequences. Private property open to the public, which includes gas stations, grocery stores, malls, parking lots, hardware stores, convenience stores, restaurants, and thousands of other locations, suddenly became off-limits to concealed carry holders. Even someone with a valid permit could not go about their everyday routine without committing a crime simply by stepping onto property where no explicit "Yes, firearms allowed" sign was posted. Not only is that unrealistic, but lawmakers drafting the bill admitted that almost no business owner would ever put up such a sign. That alone makes it clear that the goal of this rule was not to protect property rights, but to suppress concealed carry altogether. Two individual plaintiffs and two gun rights organizations challenged the law, and a federal judge initially granted a preliminary injunction blocking Hawaii from enforcing the private property default ban. Hawaii then appealed to the Ninth Circuit Court of Appeals. Instead of respecting the Bruen framework, the Ninth Circuit upheld Hawaii's bans and sided with the state. The plaintiffs then asked the Ninth Circuit for an en banc review, which the court refused to provide. This left the challengers with no choice but to request emergency intervention from the Supreme Court. In a rare move, the Supreme Court granted review. This signaled that the justices saw something deeply wrong with the Ninth Circuit's handling of the case, especially since this ruling directly conflicts with a Second Circuit decision on a nearly identical law out of New York. When two federal appellate courts issue conflicting interpretations of constitutional rights, the Supreme Court almost always steps in. And that is exactly what has happened here. What surprised many observers even more was the involvement of the Trump Department of Justice and Attorney General Bondi. They submitted an amicus brief during the emergency review stage, arguing that Hawaii's law was unconstitutional and should be struck down. Many believe their early involvement played a key role in persuading the Supreme Court to take the case. Now that the case is officially moving forward, the Trump DOJ has filed another strong brief supporting the challengers and urging the Supreme Court to invalidate Hawaii's catch-all property ban once and for all. Their brief lays out several key arguments. First, they argue that Hawaii's affirmative consent rule violates the Second Amendment because its primary purpose is to prevent lawful concealed carry, not to protect property rights. Property owners already have multiple ways to exclude firearms, including posting "no guns" signs or telling patrons directly. But Hawaii flipped that long-standing approach upside down. The state created a new default rule where carry is banned everywhere unless the owner explicitly invites it. That is the opposite of historical tradition, which allowed carry unless the owner specifically prohibited it. The Trump DOJ also notes that this affirmative consent rule results in a near-total ban on concealed carry. Since almost every location a normal person visits is technically private property open to the public, lawful permit holders would be unable to participate in ordinary daily activities while carrying a firearm. It is essentially a statewide gun-free zone disguised as a property rule. Even areas like parking lots and sidewalks that happen to fall on private land would become off-limits. The DOJ highlights that legislators responsible for drafting Hawaii's law openly acknowledged that very few businesses would opt in and post signs saying that concealed carry was allowed. That statement alone exposes the true purpose of the law, expanding gun-free zones to the maximum possible extent. The DOJ points out that states already have trespass laws and other property protections, meaning Hawaii's new approach is not about safeguarding property, but about restricting gun rights. Another major point in the Trump DOJ brief is historical tradition. The Supreme Court in Bruen made it clear that modern gun regulations must align with this nation's historical understanding of the Second Amendment. The DOJ argues that Hawaii cannot point to any historical tradition supporting an affirmative consent default ban. Instead, they say the historical expectation has always been that concealed carry was permitted unless the owner prohibited it. Hawaii's new law is not rooted in history. It is a brand new invention created specifically to defy the Bruen decision. With all of these arguments laid out, the DOJ has urged the Supreme Court to strike down Hawaii's property-based carry ban. This case has enormous implications not just for Hawaii, but also for states like New York, New Jersey, Maryland, and California, states that adopted nearly identical laws after Bruen. Instead of moving toward a constitutional shall-issue system, these states attempted to reinvent the same restrictions under new names. They tried to create a system where permits technically exist but are practically useless. The Wolford decision will determine whether states can get away with this strategy going forward. There is also the possibility that the Trump DOJ will ask for permission to participate in oral arguments. That has happened before. Attorney Harmeet Dillon represented the government side in another major Second Amendment case involving bans in Illinois. If the DOJ participates directly, it would further underscore how significant this case has become. As briefs continue to be filed, Hawaii will soon submit its response. Once oral arguments take place in January, the nation will get a clearer view of how the justices are approaching these new post-Bruen restrictions. This case will help define how courts interpret the Bruen test going forward and how strictly states must follow the Supreme Court's prior guidance. The ruling will shape not only concealed carry regulations, but also the future of other Second Amendment challenges. Having the Trump DOJ actively supporting the challengers adds even more momentum. This is a major case, and as new developments come out, I will bring updates. If you found this breakdown helpful, the best way to support the channel is by liking, commenting, and subscribing. It helps more than you know, and it ensures you never miss any of the important updates headed our way.